I was standing on my ridge, looking down at the pristine valley below, when I noticed the construction equipment rolling up the access road. My ridge. My property. The land I'd bought 6 years ago in Summit County, Colorado, specifically because it was isolated, peaceful, and completely mine. The morning had started like any other Saturday in late October. I'd woken up in my cabin, made coffee, and walked outside to check on the property boundaries. That's when I saw them. 3 trucks, a small excavator, and about a dozen people in bright yellow vests swarming over the eastern section of my ridge like ants on a dropped sandwich. I grabbed my jacket and hiked the quarter-mile to where they were working. The air was crisp, and I could smell snow coming, probably within the week. As I got closer, I could see they were already laying foundation posts for something. My blood started to boil. "Hey," I shouted as I approached. "What the hell is going on here?" A man in a hard hat turned around, clipboard in hand. He looked annoyed at being interrupted. "We're constructing the new ski patrol station for the valley. Should be done in about 3 weeks. On whose authority?" I demanded. He consulted his clipboard. "The Pinecrest Mountain HOA." All the paperwork was filed properly with the county. "This is private property," I said, trying to keep my voice level. "My private property." The foreman's expression changed from annoyed to uncertain. He flipped through papers on his clipboard, squinting at them. "The work order says this land was designated for community use by the HOA board." "Then your work order is wrong," I said firmly. "I'm William Xavier, and I own every square foot of this ridge. I have the deed, the survey markers, and the property tax bills to prove it." The foreman held up his hands. "Look, I just build what I'm told to build. You need to take this up with the HOA." "Oh, I will," I promised. "But in the meantime, I need everyone off my property. Now." He shook his head. "I can't do that. We have a contract." "If you have a problem, talk to the HOA president. Her name is Regina Owens." Of course it was. Regina Owens had been a thorn in my side since I'd moved to this mountain community. She lived in the main valley development called Pinecrest Mountain Estates, a collection of massive vacation homes owned by wealthy Denver families who came up on weekends. When I'd bought my 150 acres up on the ridge, technically within the Pinecrest Mountain area, but well outside the HOA boundaries, Regina had tried to convince me to join the association. I'd politely declined. My property wasn't part of the development, wasn't subject to their rules, and I liked it that way. But Regina didn't take no for an answer gracefully. She'd sent me letters, showed up at my door unannounced, and even tried to get the county to force me to join. Every attempt had failed because the law was clear. My property predated the HOA by 15 years, and I had no obligation to join. Now, apparently, she'd decided to just ignore property rights altogether. I pulled out my phone and called the Summit County Sheriff's Office. While I waited for them to answer, I took photos of everything. The equipment, the foundation posts they'd already sunk, the workers, the trucks with company names visible. "Summit County Sheriff's Office, this is Deputy Martinez." "Hi, my name is William Xavier. I need an officer at my property on Ridgeline Drive. Someone is constructing a building on my land without permission." "Is this an active trespass situation?" "Very active. They have heavy equipment and about a dozen workers here right now." "I'll send someone up." "Address?" I gave him the details and hung up. The foreman was watching me nervously now. "You really own this land?" he asked. "Every inch," I confirmed. "And you're going to want to stop working before you dig yourselves in any deeper." Literally. 20 minutes later, a sheriff's deputy pulled up in his SUV. I recognized him immediately. Deputy Jake Morrison had responded to a call about a bear getting into someone's garage last summer, and we'd chatted while he waited for wildlife services. "William," he said as he climbed out. "What's the situation?" I explained everything while showing him the plot markers that clearly indicated my property line. The foreman produced his permits, which listed the land as Pinecrest Mountain HOA Common Area, Lot C14. Jake looked at the permits, then at my property documentation on my phone. I'd learned to keep photos of everything after the first few run-ins with Regina. "This is private property," Jake confirmed after reviewing everything. "These permits were issued under false pretenses." "We didn't know," the foreman protested. "The HOA provided all the documentation. They said they owned this land." "Well, they don't," Jake said. "I'm going to need everyone to clear out. This is now a civil matter between Mr. Xavier and the HOA, but the construction needs to stop immediately." The foreman looked like he wanted to argue but thought better of it. "Fine. Pack it up," he yelled to his crew. As the workers began loading equipment back onto trucks, Jake turned to me. "You're going to want to get a lawyer, William. This could get messy." "It's already messy," I said, watching a truck struggle to back out on the narrow road. "But yeah, I'll make some calls." After everyone left, I walked the site. They'd managed to dig 4 foundation holes, each about 3 feet deep and 2 feet wide. They'd poured concrete into 2 of them and set posts. The ground around the construction area was torn up from the excavator, and they'd cut down 3 of my trees to clear space for the building. I took extensive photos and notes. The damage wasn't catastrophic, but it was significant. More importantly, it was a violation of my property rights that I couldn't let stand. That evening, I drove down to the Pinecrest Mountain Estate's main office. It was located in what they called the community center, a sprawling log building with a great room, gym, pool, and various meeting rooms. Regina's car, a white Mercedes SUV with vanity plates reading HOA Queen, was parked in the reserved spot closest to the entrance. Inside, I found Regina in her office, which overlooked the community's main gathering area. She looked up when I knocked, and her expression immediately soured. "William, I heard you made trouble today." "I stopped people from building on my property without permission," I corrected. "That's not making trouble, that's protecting my rights." Regina folded her hands on her desk. She was probably in her late 40s, with perfectly styled blonde hair and the kind of expensive casual where that said she'd never done manual labor in her life. "The community needs that ski patrol station," she said, as if that explained everything. "We have families skiing in the backcountry areas, and the nearest patrol station is 15 miles away. Response times are unacceptable." "Then build it on land the HOA actually owns," I said. "We don't have suitable land at that elevation," Regina said. "Your ridge is the perfect location. Central, accessible, high enough for good visibility. And private," I added, "as in privately owned, by me." Regina sighed like I was being unreasonable. "William, you need to think about the community. What if someone gets hurt? What if a child is injured and the patrol can't reach them in time?" "That's not my problem," I said. "You don't get to seize private property for the common good. We have laws about that." "We're prepared to compensate you fairly," Regina offered. "I don't want compensation. I don't want a ski patrol station on my ridge. I want my property left alone." Her expression hardened. "We've already invested significant resources in this project. The permits are filed. The contractor is hired. The community has been informed." "Then you should have verified you actually owned the land before doing all that," I said. "Here's what's going to happen. You're going to remove everything your people installed. You're going to restore my land to its previous condition, and you're going to pay for the damage you've already caused." "Or what?" Regina challenged. or I'll sue the HOA for trespass, property damage, and any other charges my lawyer can come up with. And I'll win because the law is entirely on my side." Regina stood up. "Get out of my office." "Gladly," I said. "You have 1 week to start remediation. After that, I'm filing." I left before she could respond. My hands were shaking with anger as I drove back up to my cabin. I'd moved to this mountain specifically to get away from people like Regina, people who thought rules didn't apply to them, who believed their wants trumped everyone else's rights. The next morning, I called a lawyer in Denver. His name was Marcus Webb, and he specialized in property law. I'd used him when I bought the land to ensure all my documentation was bulletproof. That foresight was about to pay off. Marcus listened to my story without interrupting. When I finished, he was quiet for a moment. "You have documentation of everything?" he asked. "Photos, video, the permits they filed, witness statements from the deputy who responded. Everything." "Good. Email it all to me. This is going to be straightforward from a legal standpoint. They built on your land without permission. That's textbook trespass. The fact that they filed false documentation with the county adds another layer of liability. What about getting them to remove what they built? We'll file for an injunction requiring immediate removal and restoration. Given the clear property lines and their total lack of authority to build, we should get it. The question is how much you want to pursue beyond that. What are my options? You could seek damages for the trees they cut, the land they disturbed, and punitive damages for willful trespass. You could also report the false permits to the county, which might result in criminal charges for fraud. Or you could accept restoration and move on. I thought about Regina's face when I'd confronted her, the complete lack of remorse or acknowledgement that she'd done anything wrong. "I want everything," I said. "Restoration, damages, and I want the county to know they filed false documents. Are you sure? This could get expensive for them and they might fight harder." "I'm sure. They need to learn they can't just take what they want." Marcus said he'd start the paperwork immediately. True to his word, by Wednesday, I received copies of the complaint he'd filed in Summit County District Court. It laid out the case clearly: willful trespass, property damage, filing false documentation with the county and seeking injunctive relief, compensatory damages, and punitive damages. The HOA was served on Thursday. Regina called me Friday morning screaming, "You're suing us. Are you insane?" "I warned you," I said calmly. "You had a week to start making this right. You didn't." "We were discussing the matter with our attorney." "Great. Your attorney can respond to the lawsuit then. This is going to cost the HOA tens of thousands of dollars in legal fees. Should have thought of that before you built on land you don't own. The community will hate you for this." "The community isn't part of this. You are. You're the one who decided to ignore property rights. You're the one who filed false permits. This is all on you, Regina." She hung up on me. I wasn't surprised. The preliminary hearing was set for 2 weeks later. In the meantime, I had to deal with the fallout in the community. Even though I wasn't part of the HOA, I knew many of the people who lived in Pinecrest Mountain Estates. I shopped at the same stores, ate at the same restaurants, used the same gas station. Word spread quickly. I started getting dirty looks at the grocery store in Silverthorne. Someone left a note on my truck calling me selfish. A few people I'd considered friendly acquaintances stopped returning my calls, but I also got support from unexpected places. Tom Hargrove, who owned a ranch on the other side of the valley, called me one evening. "Heard about your trouble with Regina," he said. "News travels fast." "It does up here. Listen, I wanted you to know you're doing the right thing. Regina tried to pull similar nonsense with me 3 years ago, wanted to run a community hiking trail through my property without asking. When I said no, she tried to get an easement through the county. What happened? I fought it and won, but it cost me time and money. She needs to learn that being HOA president doesn't make her a dictator. Thanks, Tom. I appreciate that. If you need someone to testify about her pattern of behavior, let me know. The hearing arrived on a cold November morning. The first snow had fallen the previous week, a light dusting that promised more to come. I met Marcus outside the courthouse in Breckenridge. "How are you feeling?" he asked. "Ready to get this over with?" Inside, the courtroom was surprisingly full. Apparently, the case had attracted attention. I saw several HOA board members sitting behind Regina and her attorney, a sharp-looking woman in an expensive suit. Judge Patricia Sommer presided, a no-nonsense woman in her 60s who'd been on the bench for 20 years. The hearing began with Marcus presenting our case. He showed the property documentation, the survey, my deed, and the tax records. He then showed the photos of the construction, the permits filed by the HOA, and the deputy's report. "The facts are simple, Your Honor," Marcus said. "The defendants knowingly trespassed on my client's property and began construction without permission or authority. They filed permits claiming ownership of land they do not own. They have caused measurable damage and shown no willingness to remedy the situation." Regina's attorney, who introduced herself as Patricia Holmes, argued that the situation was a misunderstanding. The HOA believed in good faith that the land in question was part of the common area, she said. There was no malicious intent. "My clients are willing to discuss reasonable compensation." Judge Sommer looked skeptical. "Counselor, the property records are public. A basic title search would have revealed Mr. Xavier's ownership. How is this a good faith misunderstanding?" Patricia hesitated. "The HOA relied on outdated survey information. That doesn't excuse failure to verify ownership before beginning construction," the judge said. She turned to Marcus. "What are you seeking?" "Immediate injunction requiring removal of all construction, restoration of the property to its previous condition, compensatory damages for the trees and land damage, and punitive damages for willful trespass." Judge Sommer reviewed the documents in front of her. The courtroom was silent except for the rustle of papers. "The injunction is granted," she said finally. "The defendants have 10 days to remove all construction materials and restore the property. As for damages, we'll need a full hearing to determine amounts. That's scheduled for." She consulted with her clerk. January 14th. Both parties should come prepared with expert testimony on restoration costs and property damage. Marcus and I left the courthouse satisfied. We had what we needed immediately. The construction had to come down. Regina caught up with us in the parking lot. Her face was red with anger. "Are you happy now?" she demanded. "Do you know what this is going to cost?" "About the same as it would have cost to ask permission in the first place," I said. "Probably less, actually." "That land would have served the entire community." "That land is mine," I said firmly. "And you knew that. You just didn't care." Her attorney pulled her away before she could respond. I watched them drive off, feeling a mix of satisfaction and exhaustion. This wasn't over, but we'd won the first round. Over the next 10 days, I monitored the removal process carefully. The same contractor who'd built the foundation had to come back and remove it. They jackhammered out the concrete posts, filled in the holes, and hauled away all the debris. They also had to remove the stumps of the trees they'd cut and grade the area to match the surrounding terrain. I documented everything, knowing we'd need proof of the work for the damages hearing. Marcus had hired an arborist to assess the value of the lost trees and a landscape consultant to estimate restoration costs. Their reports weren't cheap, but they were thorough. Meanwhile, The situation in the community continued to deteriorate. The HOA sent out a newsletter explaining their side of the story, painting me as an uncooperative landowner who was preventing important safety improvements. Several community members wrote letters to the local paper supporting the HOA, but others pushed back. Tom wasn't the only one who'd had problems with Regina's overreach. A retired couple, the Martins, wrote their own letter describing how the HOA had tried to fine them for painting their house a color not in the approved palette, even though their house predated the HOA by a decade. A business owner in town mentioned that Regina had tried to organize a boycott of his store because he'd refused to give the HOA a discount. The picture that emerged was of an HOA president who viewed her position as carte blanche to impose her will on anyone within reach, member or not. December brought heavy snow to the high country. My ridge was buried under 3 feet of powder, and the ski resorts opened to eager crowds. I spent my days maintaining my property, cutting firewood, and preparing for the damages hearing. Marcus called in mid-December with an update. The HOA's attorney reached out. They want to settle. For how much? $40,000. They'll admit fault, pay for restoration, tree replacement, and your legal fees. I considered it. $40,000 was substantial. It would more than cover my actual costs. What do you think? I asked. It's a fair offer, pragmatically speaking. You'd avoid the uncertainty of trial, but what? But they get off easy. No real consequences beyond writing a check. If we go to trial and win punitive damages, which I think we will, we could get twice that. More importantly, it sends a stronger message. Let's go to trial, I said. You're sure? Even with a strong case, there's risk, I'm sure. The damages hearing in January was more complex than the preliminary hearing. Marcus called his expert witnesses. The arborist testified that the 3 mature ponderosa pines they'd cut were worth $8,000 each based on trunk diameter, age, and replacement cost. The landscape consultant estimated restoration costs at $15,000 for grading, soil replacement, and reseeding with native grasses. Marcus also called Deputy Morrison, who testified about the scene he'd found and Regina's apparent knowledge that the property was disputed. Then came Tom Hargrove, who described Regina's previous attempts to claim others' property for HOA use. She has a pattern, Tom said. She identifies something the community wants, and she makes it happen regardless of whether she has the right. When people object, she accuses them of being bad neighbors. The HOA's defense was weak. Patricia tried to argue that the damages were excessive, that the trees weren't worth $8,000 each, that the land would have healed naturally without expensive restoration. But the real problem came when she called Regina to testify. Under Marcus's cross-examination, Regina's composure cracked. "You knew Mr. Xavier owned that property, didn't you?" Marcus asked. "I knew he claimed to own it," Regina said carefully. "Did you do a title search before beginning construction?" "We relied on our records." "That's not what I asked. Did you personally, or did you direct anyone, to conduct a title search with the county?" Regina hesitated too long. "The property was in our HOA boundaries." "Your Honor, please direct the witness to answer the question," Marcus said. Judge Sommer leaned forward. "Miss Owens, did you or anyone at your direction conduct a title search?" "No," Regina admitted, "but the county approved our permits." "The county approved permits based on false information you provided," Marcus said. "You listed the property as HOA common area when you knew it wasn't. That's fraud." "Objection." Patricia stood. "Counsel is testifying." "Sustained," Judge Sommer said. "Rephrase, Mr. Webb." "Miss Owens, when you filed for the building permits, did you verify that the HOA actually owned the land?" We believed we did. Based on what evidence? Regina couldn't provide a good answer. The more Marcus pressed, the clearer it became that the HOA had pushed forward knowing the ownership was questionable at best, assuming they could bully me into accepting it after the fact. The hearing lasted 2 days. Judge Sommer took the matter under advisement, saying she'd issue a written ruling within 30 days. Those 30 days felt long. I kept to myself mostly, working on maintenance projects around my cabin, cross-country skiing through my property, enjoying the winter solitude that had drawn me to the mountains in the first place. I also started thinking about what came next, regardless of how the ruling went. The relationship between me and the HOA was permanently damaged. Regina had made an enemy of me when she could have had a neutral neighbor. Her stubbornness and refusal to acknowledge any wrongdoing had turned a property dispute into something personal. The ruling came on a Friday afternoon in early February. Marcus called me immediately. We won. Big. How big? Judge Sommer awarded full compensatory damages. $24,000 for the trees, $15,000 for restoration, $12,000 for your legal fees. And she awarded punitive damages of $75,000. I nearly dropped the phone. $75,000. She was thorough. Let me read you part of her ruling. The defendant's actions demonstrate a willful disregard for property rights and a disturbing pattern of overreach. The defendant HOA, through its president Regina Owens, knowingly filed false documentation with the county, began construction without verification of ownership, and refused to remedy the situation when confronted with clear evidence of their error. Punitive damages are necessary to deter similar conduct in the future. How much total? $126,000, plus she's ordering you to submit the false permit filing to the county attorney for potential criminal review. I sat down heavily. This was more than I'd expected, more than I'd hoped for. It was vindication, but it was also devastating for the HOA. What happens now? They have 30 days to appeal, but Patricia would be crazy to recommend it. They'll have to pay. I'd expect a check within 60 days unless they want additional legal action. After I hung up, I walked outside. The sun was setting over the peaks, painting the snow in shades of orange and pink. My ridge was peaceful, untouched except by nature. It was exactly what I'd bought it to be. I should have felt triumphant, but mostly I felt tired. This whole situation had been unnecessary. If Regina had just asked, we could have discussed it. Maybe I would have said no anyway, but at least it would have been a conversation between reasonable people. Instead, she'd chosen to steamroll over my rights, and now everyone was paying the price. The reaction in the community was swift and divided. Some people were outraged that the HOA had to pay such a large sum, money that would come from everyone's dues. Others were furious with Regina for creating the mess in the first place. The local paper ran a story with the headline, HOA ordered to pay $126K after building on private land. The article laid out the facts clearly, and for the first time, many community members realized the full scope of what had happened. 3 weeks after the ruling, I received a formal letter from the Pinecrest Mountain HOA board. It informed me that Regina Owens had been removed as president, and that the board was conducting a full review of HOA policies to prevent similar incidents. The letter also included a personal note from the new president, a retired engineer named Donald Fletcher, whom I'd met once or twice at community events. Mr. Xavier, it read, please accept my sincere apologies for the actions taken by the previous administration. The board has reviewed the case thoroughly, and we are appalled by what occurred. We will be paying the judgment in full and have already begun implementing new procedures requiring verification of property ownership before any construction projects. We hope this incident won't prevent you from being a good neighbor to our community, even if you choose not to be a member. It was the first reasonable communication I'd received from the HOA in months. I appreciated it, though it didn't erase what had happened. The check arrived 6 weeks after the ruling. $126,000 made out from the Pinecrest Mountain HOA to William Xavier. I deposited it and immediately paid Marcus his fees, which were included in the total. The rest I kept in a separate account, unsure what to do with it. That same week, I received a call from the Summit County Attorney's Office. An investigator named Sarah Chen wanted to meet with me about the false permit filing. We met at a coffee shop in Silverthorne. Sarah was in her mid-30s, professional and direct. "I've reviewed the documents you submitted," she said. "The permits filed by the HOA contained false information about property ownership. That's a serious issue. What happens now? I need to determine if criminal charges are appropriate." This could be anything from negligent misrepresentation to intentional fraud. The question is intent. Did Miss Owens know she was filing false information, or did she genuinely believe the HOA owned the property? "The judge found willful disregard," I said. "And there's testimony that suggests she knew the ownership was questionable." Sarah nodded. "I saw that. But criminal prosecution requires a higher burden of proof. I need to establish that she knowingly and intentionally filed false documents. Do you have any direct evidence of that?" I thought about my interactions with Regina, the conversations, her complete lack of surprise when I confronted her. "Nothing direct," I admitted, "but the pattern of behavior is telling. She tried similar tactics with other property owners." She never expressed any doubt about the ownership when I confronted her, just insisted the community needed the station. "That's helpful context," Sarah said. "Let me continue investigating. I'll need to interview Miss Owens and the contractor." If the contractor knew the ownership was disputed and proceeded anyway, that's another issue. Over the next few weeks, Sarah conducted her investigation. I learned later that she interviewed Regina twice, the contractor, and several HOA board members who'd been present at meetings where the ski patrol station was discussed. What she found was damning. Email records showed that one board member had questioned whether the HOA actually owned the ridge land. Regina had responded by saying they'd work out the details after construction began. Another email showed the contractor asking for title verification before starting work, and Regina telling him it wasn't necessary because she'd already confirmed ownership with the county. Except she hadn't. The county had no record of Regina or anyone from the HOA asking about the property's ownership. She'd simply filed permits claiming the land was theirs. In late March, Sarah called me. "We're moving forward with charges. 2 counts of filing false documents with the county, both misdemeanors. Miss Owens will be charged individually, not the HOA as an entity." "What's the potential sentence?" "Each count carries up to 1 year in jail and a $5,000 fine. Realistically, for a first offense, she'd likely get probation and community service if convicted. But it's about establishing accountability." The charges were filed in April. Regina hired a criminal defense attorney, a Denver lawyer who immediately began negotiating with the county attorney's office. I wasn't directly involved in the criminal case, but Sarah kept me updated as a courtesy. The criminal case moved slowly through the system. Regina initially pleaded not guilty and demanded a trial. But as discovery proceeded and Sarah's evidence mounted, her attorney's tone changed. In June, they reached a plea agreement. Regina would plead guilty to one count of filing false documents. She'd receive 1 year probation, 100 hours of community service, a $2,000 fine, and she'd be prohibited from holding any HOA board position for 5 years. The sentencing hearing was brief. I attended, sitting in the back of the courtroom. Regina looked diminished, her previous confidence gone. When Judge Reeves asked if she had anything to say, she stood and read from a prepared statement. I made a serious error in judgment. I allowed my desire to serve the community to override proper procedures and respect for property rights. I apologized to Mr. Xavier and to the community I tried to serve. I accept responsibility for my actions. It was the first time she'd apologized. I appreciated it, though it felt more like something her lawyer had written than genuine remorse. Judge Reeves accepted the plea and imposed the agreed sentence. As court adjourned, Regina's eyes met mine across the courtroom. I saw shame there, and anger, and something that might have been regret. Then she looked away and left with her attorney. Life slowly returned to normal after that. The HOA paid for complete restoration of my ridge under the supervision of my landscape consultant. They brought in topsoil, planted new trees, seeded native grasses, and ensured everything matched the surrounding terrain. By July, you could barely tell anything had happened. The community's attitude toward me thawed gradually. People realized I hadn't been the villain in the story. I'd simply defended what was mine. Some remained resentful about the HOA's financial hit, but most understood that Regina had created the problem. I ran into Donald Fletcher, the new HOA president, at the hardware store in August. We chatted about the summer weather and the upcoming ski season. Before we parted, he extended his hand. "I want to thank you," he said. "For what?" "For holding us accountable. The HOA needed a wake-up call. We were operating like we had authority we didn't have, taking shortcuts, assuming we could do whatever we wanted because it was for the community. Your lawsuit forced us to examine our practices and fix problems that could have led to even worse situations." "I just wanted to protect my property," I said. "I know. But the impact was bigger than that. We've implemented new bylaws, new oversight procedures. Every project now requires verified ownership documentation. Board members have to take a property rights training course. We're building trust with our members and non-members alike. That wouldn't have happened without this." It was a perspective I hadn't considered. Maybe something good had come from all the conflict. That fall, as the aspens turned gold and the first serious snow dusted the high peaks, I stood on my ridge again. The land had healed. The new trees were small but healthy. The grass had grown in thick and green. In a few years, no one would know anything had been disturbed. I thought about the whole saga, from spotting that first construction equipment to standing in court to watching Regina accept her sentence. It had been exhausting and frustrating, but I'd stood my ground. I'd proven that property rights mattered, that even a well-meaning HOA couldn't just take what it wanted. The check from the HOA sat in my account, most of it still untouched except for the legal fees. I'd initially thought about using it for improvements to my cabin or maybe buying more land. But I'd come up with a different idea. I contacted the Summit County Land Conservancy and established a conservation easement on 75 acres of my property, the most ecologically sensitive areas. The easement would prevent future development permanently, ensuring the land stayed wild. I funded the easement's management with $50,000 from the settlement. It felt like the right use for the money. The HOA had wanted to build something for the community. Now, they'd inadvertently funded permanent conservation that would benefit everyone, community member or not. The Conservancy announced the easement in November. The local paper did another story. this one highlighting the permanent protection of important wildlife habitat and forest land. Several people who'd been critical of me reached out to say they appreciated the conservation effort. Even Tom Hargrove called. "Smart move," he said. "You protected your rights and protected the land. That's the right way to be a steward." Winter came hard that year. By December, the mountains were buried under record snowfall. The ski resorts were ecstatic. Families poured into Summit County for the holidays. And somewhere down in the valley, the HOA was presumably still discussing where to locate their ski patrol station, this time on land they actually owned. I never heard from Regina directly after the sentencing. I saw her occasionally from a distance. She'd moved out of the valley and into a condo in Frisco. Word was she'd separated from her husband and taken a job with a property management company in Denver. Her time as HOA queen was over, ended by her own overreach. One evening in late December, I was sitting on my porch watching the sunset when my phone rang. It was an unknown number, but I answered. "Mr. Xavier?" "This is Patricia Holmes, Regina's former attorney." I was surprised to hear from her. "What can I do for you?" I asked cautiously. I wanted to call personally to apologize. I should have advised my client differently from the start. When I took on the case, I didn't fully understand the history. I assumed it was a legitimate boundary dispute. By the time I realized how clear-cut the property rights were, I was already committed. I encouraged Regina to settle early, but she wouldn't listen. "I want you to know that I tried." "I appreciate that," I said, meaning it. "You were in a tough position." Still, the outcome was bad for everyone except you. The HOA took a huge financial hit. Regina's reputation and career were destroyed, all because I couldn't convince my client to do the reasonable thing. "That's not on you," I said. "You can only advise. She made her own choices." Patricia was quiet for a moment. "Thank you for saying that. I hope you enjoy the rest of your winter, Mr. Xavier." After she hung up, I sat thinking about the whole mess again. Patricia was right that the outcome had been bad for almost everyone. The HOA members had to pay higher dues to cover the judgment. Regina had lost her position, her standing in the community, and ended up with a criminal record. Even the contractor had lost money on the aborted project, but maybe that was how it had to be. Sometimes people needed to face real consequences for their actions. The HOA had learned they couldn't ignore property rights. Regina had learned that her position didn't give her unlimited authority. And the community had learned the importance of oversight and accountability. As for me, I got my property back, received compensation for the damage, and ensured a significant portion of the land would be protected forever. I'd stood up for what was right and won. That mattered. The story became something of a legend in Summit County. I'd occasionally overhear people discussing it at restaurants or shops. "Did you hear about the guy who sued the HOA for building on his land?" Became a common conversation starter. The details grew in the telling, as stories do. Some versions had me winning millions of dollars. Others had Regina going to prison. The truth was dramatic enough without embellishment. Spring arrived, melting the winter snow and revealing the new growth on my ridge. The transplanted trees had survived their first winter. The grass was coming back thick. I hired the landscape consultant to do a final assessment, and she was pleased with the restoration work. "In 5 years, you won't be able to tell anything happened," she said. "In 10, the new trees will be substantial. The HOA actually did quality work on the remediation." I supervised it carefully. I was grateful for that. Whatever else had happened, at least my land was healing properly. In late May, I received a letter from Donald Fletcher informing me that the HOA had purchased a parcel of land on the eastern edge of the valley for their ski patrol station. It was HOA-owned land, properly verified with all the necessary permits filed accurately. Construction would begin in July. The letter included a map showing the new location. It wasn't as centrally located as my ridge, but it was adequate for their needs. Sometimes adequate was enough. Summer brought tourists and weekend warriors to the mountains. My property remained peaceful, my sanctuary from the crowded valleys below. I spent my days hiking, fishing in the creek that ran through the lower section of my land, and maintaining my cabin. Life was good. The lawsuit was behind me. The land was restored. Justice had been served. I could finally relax and enjoy what I'd fought so hard to protect. One Saturday afternoon in July, I was repairing a section of fence when I saw a car coming up my access road. I tensed slightly, old instincts from the conflict kicking in. But as the car got closer, I recognized it. Tom Hargrove's old Ford pickup. Tom got out carrying a six-pack of beer and a grin. "Thought you might want some company," he said. We sat on my porch drinking beer and talking about everything except HOAs and property disputes. We talked about fishing, the upcoming elk season, the new restaurant opening in Dillon. Normal conversation between neighbors. As the sun set and Tom got ready to leave, he paused at his truck. "You did good, William," he said, standing up to Regina, seeing it through. "A lot of people would have given up or given in." "I just protected what was mine," I said. "It was more than that. You held a line. Property rights, rule of law, accountability, that matters more than most people realize." After Tom left, I stayed on the porch as darkness fell and stars emerged. The night was quiet except for the wind in the trees and the distant sound of the creek. This was why I'd bought this land. Not for conflict or drama, but for peace. For a place that was truly mine. The whole experience had taught me things I hadn't expected to learn. About standing firm in the face of pressure. About the importance of documentation and preparation. About how easily people with a little authority could convince themselves they had the right to ignore boundaries. But mostly, it had taught me about value. Not property value or monetary damages, but the value of protecting something important. My ridge wasn't just land. It was freedom, independence, a piece of the world where I made the rules. That was worth fighting for. As summer turned to fall and another winter approached, I settled into a comfortable routine. The HOA completed their ski patrol station on their own land. Regina continued her probation and community service in Denver. The community moved on to new concerns and controversies. And I stayed on my ridge, exactly where I wanted to be, on land that was undeniably, legally, and permanently mine. The HOA had learned an expensive lesson about property rights. They'd built their ski patrol station on my ridge, and I'd had it removed and billed them for the damages. Justice had been served, the land had been restored, and peace had returned to the mountain. Sometimes I wondered if Regina ever thought about what had happened, if she'd learned anything from the experience. I hoped so. I didn't wish her ill. I just wished she'd respected basic property rights from the beginning. If she had, none of this would have been necessary, but she hadn't, so it was. And in the end, the system had worked. The law had protected property owners. The courts had held a powerful HOA accountable. An overzealous president had faced consequences for her actions. It wasn't a story I'd expected to live through when I'd bought my mountain property all those years ago. I'd imagined peaceful solitude, not courtroom battles and criminal charges. But life rarely goes exactly as planned. What matters is how you respond when things go wrong. I'd responded by standing firm, fighting back, and seeing justice done. My ridge was mine, secure and protected, a permanent reminder that property rights still meant something in America. The HOA had tried to take it, and they'd paid dearly for the attempt. That was a lesson that would echo through Summit County for years to come, a warning to anyone who thought position or good intentions could override the fundamental right to own and control your own land. As I sat on my porch that fall evening, watching the aspens shimmer gold in the fading light, I felt satisfied. Not triumphant or vindictive, just satisfied. I'd protected what was mine. The land was safe. The fight was over. And tomorrow, I'd wake up to another peaceful morning on my ridge, exactly as it should be.